Next, I want to talk about the PPP, the Payroll Protection Program. So this is beneficial if you are a 1099, sole proprietor, or you have employees. On April 10th, they changed it, the federal government changed the regs to allow sole proprietors and 1099s to receive the Payroll Protection Program. And as of a few weeks ago, when I last checked, there was still money available. You should go to the bank that you have an account with. Odds are if you go to a bank that you don't have an account with, they're not going to accept your application. At least that's the experience I've been seeing. So you're going to go to your bank, you're going to apply for the PPP. If you're a sole proprietor, the P&L, profit and loss statement for you, will be enough. The PPP is based on 2.5 times your monthly income, whether it was a 1099 sole proprietor or for your employees' wages, and you'll receive that. It's averaged over a 1-year period. So we'll use the sole proprietor. Profit and loss says they were making X dollars a month for the last 12 months. Then they'll receive 1/12 of that, which is a monthly amount, times 2.5. That'll be a loan at 2%. However, if you use that money to pay, for example, 75% of it goes to wages and the remaining 25% goes towards rent, mortgage, or utility bills. And I should point out the 75% is wages or related wages expenses. If you do that, then that loan becomes a gift from the federal government. Same thing for 1099s or sole proprietors. If you use that to pay, if you're sole proprietor yourself, or you have 1099s or you're a 1099, and to pay yourself or your 1099s that money, the 75%, then it's a gift from the federal government. If you pay less than 75% to the sole proprietor, 1099, or employees, then there's a percentage that you have to pay back to the federal government. So that's how the PPP works. It's rather a quick process. I mean, I've been hearing people in about a week, 2 weeks are getting the money. It's designed to help people out, especially sole proprietors or small law firms. This just helps all over the place. Okay, let's talk a little about PPP and unemployment benefits. So if you have employees that are on unemployment benefits, I'm just going to throw out a number, and they're receiving a weekly benefit amount of $400. And then they'll also receive the $600 in the federal. They'll then be receiving $1,000 a week. They can receive up to $200, which is half their weekly benefit amount, in wages without impacting their unemployment benefits. So of the $400 in weekly benefit amount and the $600 in the federal, they can also receive wages of $200. However, once they receive wages that exceed their weekly benefit amount or equal it, for example, in this case, the $400, then they don't receive their weekly benefit amount, they don't receive their federal amount, and if there was a dependency for spouse or dependent children, they don't receive that amount either. Why is this important? So a lot of employers are going to have their federal and state unemployment taxes increase. The reason being is when an employee makes a claim, the employer is expected to pay that money back into the trust fund for the state. So if an employee you get one claim, your state unemployment tax rate is going to go up a little. And that's going to be over a 3-year period. If you got a lot of claims, it's going to go way up. And if you haven't had claims in a while or ever, you're at the lowest rate. However, if you've had like a turnstile operation, you may already be capped on the federal and state unemployment taxes, and so you may not have to pay much more. But if your taxes are going to increase, then by paying your employees wages that equals a weekly benefit amount, they can't claim unemployment. However, I just want to point out a caveat. You can't work out any deal, or you can't pay someone in retaliation for filing for unemployment benefits. There is a case in Illinois that says if you've retaliated against the employee for filing unemployment benefits, then they're entitled to a remedy against you. Also want to point out a couple things, some miscellaneous items. For the certification, it asks if the employee was available and able to work, and whether they were actively searching for work for each of the 2 weeks. Because of COVID-19, the able and available has been redefined. So if you can't go to work because COVID-19, for example, you can't go to work because your kids are home from school and you don't have daycare, normally you wouldn't be eligible for unemployment benefits. Now you are eligible. So when it asks how many days you're unavailable to work in week 1, it should be 0. Too many people are putting down 5 because they assume COVID-19 makes them unable to go to work. So that's not the definition. It's now 0 if that's the reason. You're fearful of COVID-19 because the governor's order prevents you going to work, although at this point you should know lawyers are an essential business under the original stay-at-home order. But if that's the case, you're entitled to undo 0 on the certification. One more item I want to talk about is the Fmla and the CARES Act. So that's been changed. The requirement is for those that have 500 or less employees, which is best as I know, that would be every law firm in DuPage. If an employee needs to take FMLA, the first 2 weeks, the employee has to use their holiday and sick pay. After that, the employer has to pay, and there's a formula on what the employer has to pay on FMLA. If they're on FMLA, they can't be on unemployment benefits because that would mean they're then ineligible because they're sick or ill, which is one of the reasons to be ineligible. So I hope this helps all the firms and employees and sole proprietors and 1099's in DuPage. I want to thank you for listening.